Good evening and welcome to Making the Case. I'm Yodit Tewolde. We begin tonight in Brooklyn Center, Minnesota, where the manslaughter trial of former officer Kim Potter shifted gears when the prosecution rested its case and the defense began theirs. Potter, who shot and killed Daunte Wright during a traffic stop back in April, says she mistook her gun for a taser. Now the defendant is facing a charge of manslaughter. BNC's Ansar Hassan is in Minnesota with the latest.
Good evening. Today was the first day for the defense, and the first witness that they called was Stephen Imes. He's a 40-year police veteran, an internationally known expert on the use of a taser. Now, during his testimony, he says when Daunte Wright resisted arrest, that changed the dynamics of the situation. And keep in mind, after the initial traffic stop, he was pulled over for expired tags. Wright was being arrested because of an outstanding warrant related to a gun charge. And Imes says police officers are under oath to, quote, overcome the resistance in a reasonable way. He says Officer Potter not only had the right to use her taser, but even lethal force if necessary. He says one of the other officers, who was also on scene, was at risk if Daunte Wright was able to drive away. Here's an exchange between Imes and the defense attorney.
An officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
Okay. So an officer seeing that could shoot?
It would meet that standard, and an officer could shoot, yes, sir.
Now, the prosecution in turn tried to paint Officer Imes as an unobjective witness. At one point, they questioned him about a report which the prosecution claims Imes wrote without seeing all the evidence in this case. That's according to a signed document. Now, the defense has two more witnesses to call. One of them will likely be Officer Kim Potter herself. She told the judge this morning that she wants to testify in this trial. Jurors have seen the body cam video. They have seen Potter's remorseful reaction. Now they'll get a chance to hear from her herself about what she thought as the events were unfolding. Now, Potter resigned 2 days after the shooting. She faces 2 charges of manslaughter. If she's convicted on either one, she's looking at several years in prison. Reporting live, Ansar Hassan for Making the Case.
Ansar Hassan, thank you so much for that report. Time to bring in our legal experts to weigh in on day 7 of this trial. Criminal defense attorneys Sue Ann Robinson and Rick Petry. Good to have you both on tonight. Let's get to it. So after the state presented more than 24 witnesses over 6 days, they finally rested their case today. Now remember, for first-degree manslaughter, the prosecution must prove that Potter acted recklessly. For second-degree manslaughter, they have to prove culpable negligence, which means that the defendant didn't do something that a reasonable, careful person would have, or they lacked the usual care and caution in doing something that others would have under similar circumstances. So neither of the charges require proof that Potter intended to kill Daunte. So has the state proven their case, Sue Ann?
I think the state has definitely met the burden for second degree. I think the fact that there was collateral damage shows how reckless her actions really were. Shooting into a vehicle where there was a possibility, and in fact, other people were injured as a result of what she did. And I think the defense's issue is going to be exactly what they're trying to do, which is showing whether or not the force that she used was excessive in the first place, whether or not even her using a taser was appropriate. And I don't think it was. I mean, the circumstance showed that they were attempting to arrest him when we've already discussed that there was a Brooklyn Center-wide memo saying not to arrest people for misdemeanors because the Derek Chauvin case was occurring. So even the fact that he was being placed under arrest when they had his name, his phone number, they knew exactly where to find him. Their job as professionals, experienced professionals under a circumstance like that, is to de-escalate. That's what they're trained to do. So it just seems whenever Black and brown people are involved, the police escalate these types of situations. And that's exactly the point of all the protests and everything that we did over the past couple of years and during COVID, and even during the George Floyd protests, is that trained police officers are supposed to de-escalate situations, and that's not what happens when it's an arrest or an apprehension of a Black or brown person.
Rick, some of the state's own witnesses may have even hurt their case under cross-examination by the defense. What are your thoughts on the strength of the prosecution's case?
Yeah, I tend to agree with you. This has been sort of an odd case. The state's witnesses, I think, did at times hurt their case. Now, I've been watching carefully, and it could be that tactically the prosecution hasn't made much ado about that. And perhaps their theory is that these witnesses are so biased that you can't rely on what they're saying. A number of them have admitted close relationships with Kim Potter and the like, that they worked with her over a number of years. I think one of the most interesting things that's developed is today, as I watched, as soon as the defense called its first witness, who, if you paid attention to his credentials, he seemed like the where-all and be-all of policing. But as soon as he started to testify, I started to become concerned that, wait a minute, he's not telling the whole truth. So this is sort of playing out in a weird sort of way. It seems like the state's witnesses aren't always helping them, but now the defense witnesses may not be helping them as well.
Right, right. Well, let's get to the defense's case in chief. It began today with their first witness, Stephen Imes, a former assistant police chief from Missouri. And as expected, his testimony countered the prosecution's use of force expert, Seth Stoughton, a law professor who called Potter's actions excessive and inappropriate. He testified that there was no need for Potter to escalate the situation, that Daunte had already been ID'd, so Potter could have let him go and arrested him on that outstanding warrant later. The expert for the defense obviously disagreed. Take a listen.
With a bench warrant outstanding for the driver, was there, in your view, an obligation to arrest him, meaning Mr. Wright?
Absolutely a mandate.
We have an opinion yesterday that the officers could have let him go because he could have been arrested later. And your response to that?
I'm going to object, Your Honor, as a statement of evidence.
The objection is overruled.
Police officers enforce the law. The order from a judge, in my experience, is literally the highest order we operate under. And if a court order, a warrant from a judge says that person is subject to arrest, they will be arrested, and there's consequences if you don't.
Now, a lot of experts are saying that the state really fumbled their cross-examination of Imes. But before I get to that, Sue Ann, when he says that there will be consequences for officers who don't make an arrest on a warrant, clearly that happens every day. I'm not an officer, but I know that I've had clients who had outstanding warrants for years, and the consequences that these officers faced definitely wasn't fatal like it was for Daunte. Your thoughts?
Please. I mean, it's all well and good for them to go into the battle of the experts and for him to feel he has to say the exact opposite of the state's witness, but you lose credibility with the jury when you say things that go against logic. Oh, a police officer has to enforce the law, so there's no way. Police officers have discretion. They have discretions for a reason. The reason why they have discretion is to prevent emergencies and be able to de-escalate situations. The same thing that is their whole defense, which is she has to make the call because she's the quarterback at the time, and she has to make decisions based on what's happening. So to sit there and say, oh no, officers aren't allowed to make those decisions, but our defense is she was making a decision, and that's why she chose to tase Daunte Wright. The entire defense's case is a big confusing mess. Kim Potter is saying what she did was a mistake. It was an accident. She regrets it. She's so sorry. That's why she's on the side of the road crying and saying she wants to kill herself and that she's going to prison. It's a horrible mistake. But at the same time, the defense has taken the time to try and put Daunte Wright on trial. They've taken the time to say they need to introduce evidence of Daunte Wright's mother having charges and Daunte Wright's supposed drug use and all these things, even though their defense is that it was a mistake. So was it a mistake, or is Daunte a horrible person who deserved Kim Potter to be his judge, jury, and executioner on that day? It's ridiculous. It's a mess.
Rick, when you have conflicting, testimony from experts, which typically does happen in cases like this, the jury tends to cancel them out. So if they can't rely on expert testimony, in helping them make a decision in this case, then what do they rely on, or what could they rely on in this case?
Well, they could rely on a number of things. One, they could just look at the evidence that's presented and conduct their own analysis and arrive at a conclusion there. I think that if Potter does testify, they'll certainly take into consideration whatever she has to say. But there are problems, regardless of whether she testifies or if she doesn't. There are problems. Their defense is sort of a multi-layered defense. On the one hand, as your other guest said, they're saying she just made a mistake. She just made a mistake. And a mistake is not a crime. That's one theory of the defense. But then they have this backup plan that even if she didn't make a mistake, that she was justified because this other officer was in tremendous danger. Now, if she testifies, and it sounds like, if I was going to fudge a bet, it sounds like she's going to testify now that she knew this other officer was half in the car, half out of the car, and if she didn't do something, that he was going to be in grave danger. But then you have to contrast that with her own statements right after this happened. She didn't say, I had to do that because I was concerned about officer safety. I saw you hanging half in and half out of the car, and I had to do it. That's not what she said. That's not how she responded. And she responded in the moment. I think that that tends to be far more credible than whatever story she may come up with now after having listened to all this testimony and being counseled by her attorney. So I think they've got some real problems here, some real problems. That expert that they called today, despite his credentials, his testimony wasn't tight. And I know that some people may be getting after the prosecution, saying they didn't do the greatest job of cross-examining him. This particular prosecutor doesn't seem to be overly aggressive or assertive like a lot of people would be. But even with what he did, this guy's testimony, I don't think is going to carry the day, and I wouldn't be surprised at all to see that the jurors say, no, this guy's he's completely biased.
Rick, I'm glad you brought the defense's strategy up, in that they're really trying to cover all of their bases, and to some degree is confusing for me, and I can't imagine what the jury is feeling. But we have more to discuss, more to unpack from today's testimony with my panel of experts, so don't go too far. More Making the Case after the break. We continue our coverage and breakdown of day 7 of the trial against former officer Kim Potter in Brooklyn Center, Minnesota. Still with me are criminal defense attorneys Rick Petry and Sue Ann Robinson. Just to go back to your point before the break, Rick, about the defense's arguments here. What I'm not understanding here is that the defense is saying that, yes, Kim Potter was justified in using deadly force, but after Daunte was shot, Potter was yelling out, and you made reference to her comments in the video, that she yelled out that she grabbed the wrong weapon and that she was going to jail. So why would she be going to jail if, under the circumstances, like the defense is claiming, she would have been justified in using deadly force? And how does the defense reconcile those two things, those two opposing beliefs for the jury?
Yeah, that's a great question. Now, and here's kind of the catch in this. Considering this is a criminal case, we have to remember that the defendant has no burden to prove anything, nothing. That's under the Constitution. But as a practical matter, once you raise these defenses and you put out these theories about why you should not be found guilty, then the jury starts looking for evidence to support those theories. And if you look at this case carefully and you look at the arguments that are being made, this is a defense based on hypotheticals, not evidence. Even the questions that are asked, the questions that were asked of the expert today, the questions that were asked of the state's experts during cross-examination were all based on hypotheticals. Even the expert today, when asked specifically about the facts of this case, whether those facts support the expert's opinion, the answer was, I don't know. I don't know all the facts of this case. So they're really taking a chance. I think you've properly identified it. They're causing a lot of confusion. They're throwing a lot of things up in the air. and hoping that the jury might bite on something there. Even if it's just one juror, remember, if it's just one juror, maybe they wind up with a hung jury. But I just, this has been, it's sort of what I expected. I know some of these attorneys, and I know their styles. I know that they can tend to be aggressive, and somewhat playing a little bit fast and loose with the facts. And considering that they don't have to prove anything, I don't know. I guess we'll see what this jury does, but it'll be interesting to watch how the rest of this plays out. I think there's another thing that's important too, and that is all of these witnesses that are referring to her, for example, as Kim. This is good old Kim, or old buddy Kim, or old friend Kim. And anybody that's tried any cases knows that unless you're talking about a young child, it is very improper to refer to defendant by their first name. It would be Ms. or Mr. or officer or former officer. It's far more formal than that. But again, here, I haven't seen the state object to that, and perhaps that's a tactical decision to show extreme bias. We'll see how it plays out when this is all done.
That's a great observation. Sue Ann, I want a follow-up question for you. Now, according to Potter, she said that she made a mistake by grabbing her service weapon instead of her taser. So that could mean that she, again, knew that using deadly force wasn't justified under those circumstances. So why would the defense hone in so much on whether deadly force was justified and not just focus on whether using her taser, which she intended to do, was justified? I mean, you're a defense attorney. I know that we gotta throw everything at the wall and see what sticks. I get it, but I think it's just confusing when you're focused on one thing and your own client wasn't even trying to use that one thing, right? She was trying to actually, according to her, de-escalate the situation by using the taser.
I think that the defense, honestly, is going into their SOP for defending police excessive force cases. Hey, let's talk about how bad this guy was. Let's try to dig into his family a little bit so that the jury doesn't feel as bad for that this person passed away. Let's try that, because that was the standard in police excessive force cases, I would say, for years pre-Derek Chauvin conviction. Also, even with police witnesses, remember Derek Chauvin's case is when the blue wall of silence came down. So even when the state had police witnesses, it was a little different because, as your other guest pointed out, they're talking about her as Kim and, our friend Kim and our colleague Kim, because it's not the same situation as when Derek Chauvin's case, where nobody really liked him. They weren't cool with him. He was persona non grata in a way, so officers happily threw him under the bus and said everything he did was unreasonable. I think here, that's really the difference. They're having to testify, but they're trying their best to kind of skirt around the fact that good old Kim did something reckless that caused collateral damage to other people, and she herself said out of her own mouth that she should be held accountable and go to prison for it.
Now, in the afternoon, the defense called up a string of character witnesses. Most of them were former colleagues of Potter, all of whom spoke highly of her. And one of them was Officer Colleen Fricke. She called Potter a mentor and a friend, and she talked about being with Potter after the shooting. Take a listen.
Did you have a chance to observe Officer Potter while she was at the Brooklyn Center Police Department in a room by herself?
I did.
What did you observe in that regard?
I saw her curled up in the corner of the room.
What room was she in?
She was. It was a meeting room. I don't know a name for it.
Was she by herself?
Yes.
Rick, why is the defense allowed to call character witnesses? Because, I mean, the issue before the jury is whether Potter's actions were criminal, not to determine whether she's a good person or not.
Yeah, that's a good question. You can certainly call character witnesses, open the door to that type of testimony. It's really not relevant. It's just everybody saying she's a nice person. But here's the reality of it. Sometimes the nicest of people do, things that are illegal or bad things. That's just the reality. And there's another point here. Now it showed up twice. Let's put this in a little bit different context. Let's think about those cases where police officers place freshly arrested defendants in the back of the squad car. They leave them back there by themselves. They turn the recording devices on, whether it's audio or audio and video, in hopes that the person will get in there and start talking to themselves out loud, saying things like, dang, I can't believe that we got caught, or I shouldn't have done this, all those kinds of things. And then they turn right back around and use those statements against that defendant. Well, that's basically the same thing that we have here, except instead of being in the back of the squad car, we have these body camera videos that are seeing her making a statement against interest, basically her confessing. And then even with the testimony that that officer provided about her being curled up in the corner of the room, yeah, you might say, well, she's a good person feeling bad because she did something. But it can also go to this fact that she realized that what she did was wrong and it was illegal and that she was going to have to be held accountable to it.
Now, Sue Ann, in that same courtroom where Potter is being tried for manslaughter, Derek Chauvin was convicted of murdering George Floyd, and a slew of officers, former colleagues of his, the chief, all of whom testified against Chauvin, not calling him a good person, condemning his actions. And that made it easier for the jury, to pick the side with the strongest evidence. Here, both sides have officers and experts testifying. How problematic will it be for the prosecution hearing these other officers talk about how good of a person this officer is? I mean, it's already hard enough to charge officers, much less get a conviction. I mean, now you're hearing that this woman is a good, upstanding citizen. It's going to be hard for these jurors to separate the person from her actions.
And that's really the only play the defense has in a case like this, where the defendant has admitted her mistake and admitted that she should be held accountable. The only play they have is to play on the sympathies of the jury for her being remorseful and to say, hey, she's a really, really good person, never done anything wrong before, so maybe under this circumstance, you give her a break. That's really the only play the defense has. And again, as I said before, at the end of the day, as good as she is or was, or as great of a mentor she was to other officers, she made a bad call, and she knows she made a bad call under the circumstance. And I think her defense team is actually hindering her defense in the sense that they are throwing things against the wall. They are raising issues about Daunte's blood alcohol level and trying to get in evidence about his past experience with police, and doing a cross-examination of his mother who had to witness everything through the phone. I don't think that's going to play well to the jury. The jury is going to say, listen, if this is a mix-up, then we don't need all of this. Let's just tell us that it's a mix-up, if that's what it is. But I think that them trying to throw everything against the wall is not just going to confuse the jury, but it's going to clarify something for the jury. And hopefully what is clarified is that Kim Potter's actions were reckless.
Rick, last question to you. Sue Ann says, hey, just tell the jury that there was a mess up, a mistake, a mix-up. And that's what Kim Potter plans on doing. She already made that very clear to the court when the judge asked her if she had changed her mind about testifying. She will be testifying tomorrow. This is after the jury is hearing these colleagues talk about how great of a person she is. This is going to be very impactful for the jurors. It could be in a bad way and it could be in a good way. I'm guessing that it's going to be in a good way because they're already going into this believing that she's a good person, I'm guessing. So your thoughts on how this could definitely seal the case for the defense?
Yeah, that's a good point. They certainly pre-framed her as, this wonderful person, a good mentor, all of these things, never been in trouble, has always followed the rules, trains other police officers on how to do things. So I think you make a good point there. At the same time, all of that goes to, especially the training piece and the good police officer piece, also goes to the fact that if all of that is true, then you can't make these mistakes. You can't make this kind of a mistake. So it'll be interesting to see. Part of me says that considering the way this case has gone so far, that it might be hers to lose with her testimony now, but she's going to face some tough questioning. Again, going back to, if she says that, well, I saw this other guy in the car and I was concerned about his safety, but that's not what she said at the time. All these other theories being floated, I think that they can impact her credibility, notwithstanding that she's been pre-framed as this person that basically could walk on water. But we'll have to see how it goes.